This is one of the juiciest space news heard in recent times. Imagine waking up one morning to find a steaming pile of multi-million-dollar space tech sitting in the middle of your living room, and looking up, you see that your roof was torn open. Well, a similar thing happened to a family in Florida recently, and it looks like NASA may face some heat for it. Do the Oteros have a legitimate claim against NASA? How liable is the space agency? And should we expect more incidents like this in the future? Let's talk about it. On the 8th of March 2024, a small cylindrical object fell from the heavens aimed at a seaside neighborhood in Naples, Florida. Before anyone could blink, the object had torn into the roof of a home belonging to the Otero family, ripped through 2 floors, and crashed into the ground floor. Thankfully, Daniel Otero, the homeowner's 19-year-old son, was lucky to escape unscathed. Had the object landed a few feet away from where it did, he would have surely been severely injured at best. 2-pound metal object falling from that height could easily kill a person with a direct hit. So what is this mysterious object? Well, it turns out that it was a support for a cargo pallet battery mount. The pallet had serviced the International Space Station, ISS, up until 2021, when it was jettisoned and seemingly forgotten about. The pallet weighed about 5,800 pounds when fully loaded with nickel hydride batteries. The plan was that, as usual, the pallet and all of its components would linger in orbit for about 2 to 4 years before disintegrating from friction with the Earth's atmosphere during re-entry. Unfortunately, this relatively small metal component survived somehow and made its fateful journey toward the poor beach house and the unsuspecting teenager. Shortly after the crash, the supporting piece was taken to the Kennedy Space Center in Cape Canaveral to be studied. It was here that the object was identified as NASA flight support equipment from the ISS. The space agency also issued the standard public relations statements that you would expect after such incidents. A month after the crash, NASA reaffirmed its commitment to responsibly operating in low Earth orbit and mitigating as much risk as possible to protect people on Earth when space hardware must be released. Obviously, the Otero family is not convinced about NASA's true level of commitment to safe space garbage disposal, and they are currently suing the agency for damages to their property and the distressed family members suffered in the wake of the crash. The claim, which has been filed under the Federal Tort Claims Act, seeks compensation for damages to non-insured property, business interruption, cost of assistance from third-party agencies, and emotional and mental anguish. The claim seeks compensation of just over $80,000 US. The family's legal representatives have accused NASA of dangerous negligence that could have resulted in serious injury or even loss of life in addition to the property damage it caused. They are confident they can secure a favorable ruling in what would be a precedent-setting case for issues like this. Lead attorney Micah Nguyen Worthy has asserted her wish to see her clients made whole and the preemptive setting of precedent to protect others who may suffer similar incidents. At this moment in time, a precedent case at the federal level makes sense. From satellites and rockets to telescopes and space stations, there is an unprecedented level of space traffic today. With even more satellites planned for launch and ever more frequent rocket launches, we will have even more space traffic before long. And as space traffic increases, so does the likelihood of such crashes taking place. As such, it would be easier for future claimants in a similar position to sue and, hopefully, get a speedy resolution. Massive entities like NASA can afford cases that drag on for years, but everyday civilians usually cannot. Precedent in this matter could also make class action lawsuits possible in the future. A class action suit, also known as a representative action, is a type of lawsuit where a collective group or class of people is represented by a few members of that group. An example of a class would be 100 families whose homes have been damaged by falling space debris. A precedent case would also make life easier for courts. If similar cases pop up in the future, courts will have a trodden path to follow, or at the very least to serve as a guide. NASA itself would benefit, at least in the long run. Losing a case of major public interest might just be the catalyst for the development of safe and sustainable methods of dealing with space garbage and debris. If the agency continues with its current methods, and if cases like this keep popping up, its reputation may suffer a critical hit. And with massive plans, including the Artemis moon missions, on the horizon, NASA needs every bit of positive PR it can get. Spending billions of taxpayer dollars would be much harder if those same taxpayers were worried about spacecraft and satellites falling on their homes and kids. kids. So far, NASA has yet to comment specifically on the Otero case, which is understandable. However, the agency has up to 6 months to respond formally to the suit. The outcome promises to be a landmark moment for NASA and its relationship with the public, and it may guide future cases for years or even decades to come. In the meantime, at least, this case has brought the issue of space debris and its potential hazards to the public consciousness. With all that said, do the Oteros have a legitimate claim? Well, only a US federal court can answer this question definitively. You see, there is no clear or specific US law governing liability for damages caused by space debris, which is why the Otero case may drag on for quite a while. When the law is absent, unclear, or unspecific, the courts may take on the responsibility of shaping the law through precedent. In this situation, the Oteros and their lawyers are hoping their case will become the precedent for future cases. The main law that will be in play here is the Torts Act, which is used to determine liability based on whether a claimant's loss or suffering is a direct result of the wrongful actions or inactions of the defendant. In this case, the court will deliberate about whether the Otero's damage, pain, and suffering was a direct result of NASA's actions or negligence. The US legal system is also likely to catch some criticism for the lack of standalone space debris laws. After all, the United States is the world leader in space exploration. Many experts would argue that space debris laws are something that should be in the pipeline at the very least. Luckily, the courts can also call upon international law to guide them. There is the Outer Space Treaty of 1967, of which the United States is a member nation. This treaty places liability for damage to people or property squarely at the feet of the nation that launched that particular damage-causing agent. If we only go by this treaty, NASA and the US government are liable. In fact, the US would still be liable if the debris fell in another country too. In 1972, the United Nations, UN, came up with the Liability Convention to deal with the issue of space-related damages and liability. The UN's convention essentially underlined and updated the Outer Space Treaty. However, while these international laws would certainly be applicable, had NASA's object fallen into another country, they are not binding in a case like this. If an American space object causes damage on American soil, then the matter is subject to American laws and courts. The Outer Space Treaty and Liability Convention can only serve as guides for judges. The incident with the Otero home is far from the first time people have had close run-ins with man-made objects falling from orbit. A woman named Lottie Williams from Oklahoma was struck on the shoulder by a small piece of woven metallic material from a Delta II rocket's propellant tank. She did not suffer any injuries. In 2002, 6-year-old Wu Ji achieved the unlucky milestone of being the first person to get hurt from direct space debris impact when a 10-kilogram block of aluminum hit him in Shaanxi Province, China. He suffered a fractured toe and a swollen forehead, but lived to tell the tale. Then, in 2024, 2 months after the incident at the Oteros' house, another roof was struck. This time, a small fragment from the SpaceX Crew 7 Dragon spacecraft struck a house's roof in Macon County, North Carolina. As you can see, space debris is real, and we need a real solution for it before someone gets seriously hurt or worse. That brings us to the end of today's video. Thank you very much for watching, and please take the time to like and share the video. We also hope you subscribe to the channel and ding the bell so you never miss out on more cool space content. Until next time, bye for now.